Assalamu alaikum. Honorable former Justice Muhammad Imdadul Haq Azad, now President of Lawyers Guild Bangladesh, Mr. S.M. Goshami, Senior Advocate Supreme Court of Bangladesh, Chairman of BIMF, distinguished guests, participants, ladies and gentlemen. A very good afternoon to all of you. At the very outset, I consider it a great privilege and honor for me to address before you as the chief guest of this workshop on evolution of mediation, ADR instead of village court, jointly organized by Bangladesh Mediators Forum and Lawyers Guild Bangladesh. Let me start by expressing my gratitude to everyone involved in organizing today's event. To this end, let me appreciate and congratulate everyone present today in this workshop. I'm glad to be here with you today for giving me the opportunity to share my experiences. The panelists of this workshop have discussed already on the subject matter in detail. You have already heard about mediation in Sri Lanka, evolution of mediation, mediation in Nepal, mediation in Arab world, mediation in Bangladesh, and also about online mediation and village court. However, I'd like to give some of the tips on the subject matter very precisely. In modern world, alternative dispute resolution has become very popular as an alternative route to reaching a speedier and less expensive mode of settlement of disputes. It includes mediation, arbitration, negotiation, and conciliation. Most of the countries of the world are now adopting ADR mechanism and achieve success in reducing backlog of cases and increasing access to justice for all. Hence, before it's too late, it is high time to search for an effective method to solve this problem of backlog of cases in our country. ADR is not something new concept in this subcontinent. In ancient India, the whole village, by way of Gram Panchayat, is to solve the problems of villages sitting together and mediating the problems faced by the two parties. Likewise, rural Bangladesh has a long tradition of being shalish in family matters or in minor disputes. Shalish is still the most effective procedure for quick and useful legal redress. In Islam, the Prophet Muhammad ﷺ has always asked Muslims to settle the disputes between their believer brothers amicably. A true Muslim does not nurture conflicts but rather attempts to solve them. In that sense, we can say that culture of alternative dispute resolution older than any other legal instruments we have at our hand today. Nowadays, arbitration and mediation are the most popular ADR form in the world. Arbitration is widely used to resolve trade and commerce disputes in both the public and private sector all over the world. It is considered to be more efficient process than litigation because it is quicker, less expensive, provides greater flexibility of process and procedure. Now let us focus on international arbitration. As you know, it is arbitration between the companies or individuals in different states, usually by including a provision for future disputes in the contract. The predominant system of rules is the UNCITRAL arbitration rules, as well as the United Nations Convention on Enforcement of Foreign Arbitral Awards, known as New York Convention. Most international arbitration institutes provide rules which govern the resolution of disputes to be resolved by arbitration. The known rules of arbitration include those of International Chamber of Commerce, London Court of International Arbitration, the International Center for Dispute Resolution of the American Arbitration Association, Singapore International Arbitration Center, SIAC. Investment arbitration are often resolved under the rules of World Bank's International Center for Settlement of Investment Disputes, or the United Nations Commission or International Trade Law. The best treaty known as the New York Convention, which entered into force in 1959, until then over 150 countries have ratified the New York Convention. That means arbitration hours can be enforced in approximately 3/4 of the countries recognized by the United Nations. Bangladesh is a party of the New York Convention. In the early days after independence, arbitration in Bangladesh was governed by the Arbitration Act 1940. In order to rectify these shortcomings, Bangladesh enacted the Arbitration Act 2001 based on the ancestral model law. However, it is in fact that arbitration in Bangladesh have earned the reputation of being as expensive and time-consuming, since the enforcement of arbitration hour is not time-bound. Compared to arbitration, mediation is better opportunity in Bangladesh. As you know, mediation is a process where a neutral and independent third person, mediator, helps the parties in a dispute to reach their own solution. In the words of Professor Hazel Jain, mediation as a voluntary process where a neutral mediator attempts to help the disputing parties to reach an agreement that is acceptable to both sides and that will bring the dispute to an early conclusion without going to court. In mediation, mediator does not decide who is right or wrong, but rather helps the parties to come to a mutually acceptable agreement. In fact, mediator acts as a shuttle diplomat between the parties and exchanges offer and counter-offers between them. The beauty of mediation is that in mediation, each party has the opportunity to voice their own point of view. They do not take sides. Mediator does not impose a solution or give tactical advice. It is flexible, time-bound. Also, the procedure is speedy, efficient, cheaper, and confidential, which my earlier speaker already mentioned that the benefit of mediation is confidential. With extremely backed-up courts, with over 4 million cases pending in courts, Bangladesh suffers from a severely overburdened legal system. That is why we need to make the ADR system part and parcel of our judiciary. There are a number of legislation in Bangladesh that have specifically provided for the provisions relating to ADR, particularly mediation and arbitration in civil matters. The Contract Act 1872, Section 28, Code of Civil Procedure, Muslim Family Laws Ordinance 1961, Family Courts Ordinance 1985, Arbitration Act 2001, Authoring Adalat Ain 2003, Income Tax Ordinance 1984, Value Added Tax Act 1991, Customs Act 1969, Village Code Act 2006, Labor Code Act 2006, EPZ Trade Union Industrial Relation Act 2004, Real Estate Development and Management Act 2010, and Legal Aid Act 2000. All these have the provision of ADR, the arbitration or mediation procedure to follow. In Bangladesh, legislature has incorporated mediation arbitration provision by amendments in Section 81A to 89AE of the Code in 2003. This amendment in 2003 introduced the court and its mediation and arbitration as integral part of civil proceedings in Bangladesh. However, at that time it was discretionary. Later on, the Act went through another amendment in 2006 that introduced the provision of mediation even at the appellate stage. The code was again amended in 2012 that made the mediation system mandatory in civil proceedings. And it was again amended in 2017 that made provision to refer the dispute or disputes to the concerned legal aid officer. In criminal jurisdiction, ADR has not been yet widely introduced in Bangladesh. However, Section 345 of the Code of Criminal Procedure enacts provision for compromise and compoundable offences. In this connection, the case of Joinal versus Rostam Ali, reported in 36 JLR AD, page 240, Honorable Chief Justice of Bangladesh, that Justice Budrul Hada Chaudhry said that they encourage settlement of dispute either by panchayat or by arbitration or by way of compromise. And if it is a criminal offense, the offense can be compounded within the limit of Section 345 of Code of Criminal Procedure. So we have limited scope for compromise in criminal litigation in Bangladesh. So we have to try to solve the problem, legal issues, other things, through arbitration or by mediation, which is the better option for the litigant people. For the peace and development are interrelated. The various forms of development need a peaceful environment to sustain. Therefore, methods of dispute resolution like arbitration, mediation become imperative in this respect. International mediation in violent national conflict has long been undertaken by the United Nations, the African Union, and the multilateral organizations. In Africa alone, over the past 3 decades, mediators have endeavored to end deadly conflict in Angola, Burundi, the Comoros, the Democratic Republic of Congo, Ivory Coast, Kenya, Liberia, Madagascar, Rwanda, Somalia, Sudan, Uganda, Zimbabwe. So we can see that ADR has vital role to resolve deadly national conflict between the countries as well. Even for the ongoing war between Russia and Ukraine, I believe mediation is the best possible option to end the war. Now, something about online mediation, you have already heard about it from an Indian speaker. Since 2020, due to pandemic, we know the whole world was in crisis, especially at the time the Western countries are increasingly using different forms of technology and online dispute resolution, platform for mediation or arbitration, which allow the parties to negotiate remotely, maintaining the social distancing by virtually using smartphone, tablet, computer, or other similar technology, practically from any location, and that practice is still going on. So we need to take necessary steps about online dispute resolution to be effective in Bangladesh as well. Our economy is growing rapidly, bringing its business to close contact with outside world. Many foreign companies are now investing in Bangladesh. Therefore, effective steps towards alternative dispute resolution is needed to make Bangladesh an investment-oriented country. And I believe that we need an international academy for dispute resolution in Bangladesh. And also, I think it is the high time for Bangladesh to be a signatory of Singapore Convention. The United Nations General Assembly adopted the convention on 20th December 2018. It is known as the Singapore Convention on Mediation, and also the first UN treaty to be named after Singapore. Till that, the convention has 57 signatories, including India, Sri Lanka, Maldives, Turkey, Korea, Malaysia, Saudi Arabia, China, USA, and other countries. The Singapore Convention ultimately aims to facilitate international trade and commerce by rendering mediation an effective and entrusted method for resolving cross-border dispute alongside with arbitration and litigation. Now, regarding ADR, our former late lamented Honorable Chief Justice, Honorable Justice Mustafa Kamal said, ADR is a non-formal settlement of legal and judicial disputes as a means of disposing of cases quickly and inexpensively. It is not a panacea for all evils, but an alternative route to a speedier and less expensive mode of settlement of disputes. It is voluntary, cooperative way out of impasses. We know that judiciary of Bangladesh is overburdened with millions of cases, and the number is mounting day by day with institution of fresh cases due to number of factors, including inadequate number of judges in terms of pending cases, procedural formality, complexity, poor logistic support, and corruption are the main reasons for backlog of cases in our country. In this background, you can easily understand the importance of promoting ADR in our judiciary to reduce the backlog of cases. The famous words of US President Abraham Lincoln, emphasizing the profound significance of ADR, said that discourage litigation, persuade your neighbors to compromise whenever you can. Point out then the nominal winner is often a real loser in fees, expenses, and waste of time. Thus, ADR should be part and parcel of our judiciary, considering the huge backlog of cases. We should encourage litigant people to go for mediation or arbitration, not for litigation. Rather, litigation should be the last resort. My suggestion is that three organs of the state, the executive, legislature, and judiciary, should work shoulder to shoulder to make the ADR a popular way forward to achieve United Nations SDG 16. ADR offers advantages of affordable simplicity, like win-win outcomes. Hence, policy and legal reformers globally have increasingly embraced ADR to accelerate the progressive realization of SDG 16 access to justice vision. I believe that by introducing mediation and arbitration successfully in our judicial system, we'll be able to solve this problem and open the door of justice to all by implementing the theme, mediate or arbitrate, do not litigate. There is a saying that justice delayed is justice denied, and also Martin Luther King said that injustice anywhere is a threat to justice everywhere. Again, justice hurried, justice worried. So we have to find a middle way to solve this problem. And I trust that, considering the huge backlog of cases, in our country, ADR is the best possible option to work on this situation, to ensure justice for all. In my opinion, to make the ADR mechanism effective in Bangladesh, certain necessary steps need to be taken. Number one, judges and lawyers should be properly trained up. Public awareness should have to be made to promote the ADR system popular. A statutory body should be incorporated for formulating rules, planning, and monitoring the whole ADR system. That is like a commission for alternative dispute resolution. I think in this regard, BIMF can take initiative and make a proposal, or Mr. Abdul Rahman is here. He can also propose to the present government regarding this, the commission or something like that for ADR alternative dispute resolution. Positive impressions should have to be created among the lawyers regarding ADR. To ensure the independence of judiciary and transparency of prosecution, further corruptions have to be removed or at least minimized from all sectors to achieve the best result for ADR and ensure justice for all. ADR to be made mandatory in certain cases. Finally, integrating ADR in legal education. That is very important. If you learn that in the present situation, we have 4 million cases pending. If the students are aware of ADR system, they will encourage the litigant people to go for litigation. Instead of litigation, go for arbitration or mediation. Furthermore, there is no mediation law in Bangladesh. However, in neighboring countries like India, Nepal, Sri Lanka have mediation laws. The Mediation Act institutionalized the mediation process, allowing people to opt for mediation without filing a suit, which will significantly reduce the number of cases and burden on the courts. The Mediation Council should be in place to oversee the accreditation, training, and other mediation-related issues. It should also provide a fixed time frame for the process to avoid delays in mediation and to ensure timely access to justice. It should also acknowledge online dispute resolution. A similar mediation law in Bangladesh, like other countries, can promote a people-friendly dispute resolution system, which can ultimately strengthen the overall dispute resolution system in Bangladesh and thereby reduce the number of cases and burden of courts. Now, something regarding the village court, which is established to strengthen the local justice system in rural areas by establishing close to home, low-cost courts that adjudicate a minor dispute between the residents of the rural areas. Village court is also known as alternative dispute resolution court. In fact, village court is a semi-formal dispute resolution mechanism founded on the concept of alternative dispute resolution. Village Courts Ordinance 1976 was enacted to ensure speedy and easy settlement of minor disputes among the local people in the rural areas. The Village Court Act 2006 6 was enacted by repealing the ordinance, and some sections of the Act were amended in 2013. In 2013, by amending the Village Codes Act, the government increased the power of this court to impose fines from 25,000 to 75,000. Again, the Village Code Act 2024 was passed in the Parliament with an amendment enhancing the authority, raising the amount from existing 75,000 to 3 lakhs. Through Village Code, the people of the village, especially women and backward communities, supposed to getting the opportunity to settle their minor disputes at the local level at a low cost. It is constituted under the Section 5 of the Village Code Act with 5 members, where 1 chairman, 4 members are to be nominated by each of the parties. To the dispute basically deals with civil cases including family matters, land disputes, property, marriage, divorce, etc. And some criminal offences as well. However, you have already heard from the earlier speaker, there is immense biasness in judges within this system, mostly due to political affiliations. The law empowers the chairman and members of the union periषद as participants of the court, but in most cases the judges panel is elected or nominated by the political parties in a way where dispute the mandatory provision of including female member, they are not followed. For this reason, there is a greater chance of biasness. Needless to say, the UP chairman and secretaries should be properly trained up, especially on the legal and procedural aspects of village code, in order to overcome this situation. But the situation is different. Moreover, in Bangladesh, in this regard, we should think proactively about how to deal with the issue. Presently, the system is not working properly. So we have to think about how to act in the present situation. Especially, frankly speaking, in reality, village code is not working up to the expectation of the rural people. Number of reasons are there, as stated above, why village code not functioning properly in line with its aims and objectives stipulated in the Village Code Act 2006. We all need to think deeply how to solve this problem, or alternatively, introduce the full-fledged ADR system instead of village code in rural areas to overcome this situation. So there's 2 alternatives now. We try to improve the village code system, or we have to abolish this. Alternatively, introduce full-fledged ADR system instead of village code in rural areas to overcome this situation. According to the Ministry of Law, Justice and Parliamentary Affairs, disposing of over 1 million cases pending in the courts in Bangladesh, it would take at least 86 years if no new cases are filed. These pending cases are not only making the litigant public suffer, but also cause loss to the state. The judicial system will collapse unless the remedial steps are taken immediately by the state. And I believe to reduce the burden on the courts, there is no alternative to alternative dispute resolution. So before I conclude, I would like to extend my big thank you for the guests from overseas and the Bangladesh Mediators Forum, Lawyers Guild Bangladesh, to arrange such a fruitful workshop on ADR. I would also like to express my gratitude to the BIMF for their continuous support to promote ADR in Bangladesh. Special thanks to Mr. Dushani for his contribution in the legal field of ADR in Bangladesh. He is in fact a torchbearer of mediation in Bangladesh, and I wish Bangladesh Mediators Forum and Lawyers Guild Bangladesh all the success in the coming days, especially under the leadership of Honorable Justice Imdadul Haq Azad, Lawyers Guild Bangladesh. I believe will contribute to the judiciary. I hope that all of you have enjoyed the workshop. Long live Bangladesh Mediators Forum, long live Lawyers Guild Bangladesh. Once again, thank you for listening to me with great patience and best wishes for all of you. Thank you very much.